Good afternoon, Senator.
Good afternoon, Chairman McDonald, members of the Judiciary Committee. Thank you very much for allowing us to come up in this hour, and our testimony will be brief. I'd like to reserve the balance of my time for my constituent and that of Representative Roldan, Ms. Luz Torres Sullivan. But we are here to testify in support of Committee Bill 543, an act concerning sentence review, which maybe more appropriately should be considered as concerning sentence modification, because that's the real thrust of the matter before us. And currently, Mr. Chairman, the Connecticut law allows for a review and consideration of a modification of a sentence in two ways. One, before the Judicial Review Division, the Sentence Review Division of the Superior Court. And in that particular process, that access to that must take place after someone has been sentenced to greater than 3 years, but is prohibited to someone who has a mandatory minimum sentence. The sentence has resulted in the court's acceptance of a plea agreement, or 3, the sentence was imposed for less than the plea agreement. The second approach has where the applicant must apply to the court, and the prosecutor must agree to have the review take place. It is, and again, I'll have Ms. Torres Sullivan speak more specifically to why we are here, but I'm sure that members of this committee can appreciate with respect to getting access to the review division, the sentence review division, that if one takes a plea agreement, accepts a plea agreement, there might be any number of reasons why you would do that. Ineffective counsel, a lack of resources to be able to pay for counsel to continue to fight a matter, family considerations, and any other reason why someone would accept the plea, and to restrict that as a reason to be able to get a sentence review. It doesn't assure a modification by any means, but to get a fair hearing in those instances where it might be warranted seems to me to be an unfair block on that process. So I'll ask Ms. Torres Sullivan to speak specifically in her matter, if I could, Mr. Chairman.
Good afternoon, members of the Judiciary Committee. My name is Luz Torres Sullivan. I'm here to speak on behalf of 543. This bill will not only help my husband, but it will help other members that are seeking such sentence modification. My husband, Brian Sullivan, was sentenced to 28 years to prison for drug-related charges, in which those 28 years he has already served 12. I feel that 28 years was a harsh sentence due to the fact that my husband had a drug problem and was not given opportunity through the court to get into a drug rehabilitation program. The charges were extreme. This bill will help me seek for sentence modification, which I feel that I have been trying for the past 4 years, and I'm seeking that legislation put into practice a sentence modification and review process that is quick, efficient, and fair. In conclusion, I want to say that my husband has changed his life around and deserves a second chance. He has been a role model inmate. He has rehabilitated himself through the program that DOC has offered him. He accepted Jesus Christ into his life as his personal Savior. Here I have a package that I would like to leave with the chairman of a sentence modification that he applied for 3 years ago, which proves the rehabilitation process that he's been through, including copies of all certificates that he had received, as well as program that he had completed, and also of all good evaluation and performance that he also had received while incarcerated. I know this bill will not only help my husband, like I said in the beginning, but it help others as well that had been rehabilitated themselves. In this tough economic times, which everything that we are facing now, everything is being cut. Also, the Department of Correction has also been cut. and the prisons are overcrowded. People are sleeping on the floors. The population system is supposed to hold only 17,000 inmates, and right now there's like 21,000 inmates in institutions. And I feel that more programs such as halfway houses, parole, probation, and other programs to alleviate this prison overcrowding should be established. Right now, the daily basic needs such as toilet tissue, soap, toothpaste, and other important items for their basic needs are also being cut. I know this to be true because I'm also the coordinator for a prison ministry out of the New Dimension Christian Center. We also, myself along with 14 members from my church, we deliver religious services to 11 prisons here in the state of Connecticut. I would like to read three key points why this bill is so important. The first point is judges who sentence people often say that a person sentenced should take all rehabilitative programs and then come back to the court, but without the prosecutor or the prosecution giving them a chance to come in front of the judge, this is not possible. Sentencing judges are the ones who decide if a sentence can be modified. If someone turns their life around and demonstrate that he'd been rehabilitated, shouldn't a judge decide on all the facts? Even Judge Norco, a well-respected judge, a long time ago, recognized the need for society to pay attention to those who have rehabilitated themselves through the program that DOC offered. The only way that can happen if allowing a judge at least the information of someone has done while incarcerated. Thank you very much.
Well, thank you very much for your testimony and for sharing some of the experiences you've had with your family in the criminal justice system, but also thank you for the ministry work that you do as well. It's probably one of the unsung things that go on in our system that really should be acknowledged, and I appreciate those efforts. And I certainly appreciate you bringing this issue to Senator Fonfara's attention. He and I have had a couple of conversations about this issue, and frankly, I had not focused on this before, so you've got a very effective advocate on your sitting next to you. And let me just ask perhaps a question to you, Senator Fonfara. As I understand this proposal, it really is to create uniformity within the statutory framework to allow any sentencing court, regardless of the length of the term of the sentence, to review a sentence upon good cause shown. Right now, we have sort of a random, arbitrary 3-year number where a judge could do that unilaterally for 3 years or less, but only would have that authority if the state's attorney's office approved of it for 3 years or more. And in researching this information, did you come up? Did you see any rationale to why the 3 years was picked in when it was originally implemented into the legislation?
I have not, Mr. Chairman, and I can say that while there are some states that have a greater period, there are other states that have, the majority of states that I've in the review have no period whatsoever. And in this particular case of Ms. Torres Sullivan's husband, the application has been before the state's attorney's office for 4 years, and it has not been denied, it has not been approved. It sits there, and there's been no action taken on the application. So that's one thing. The second is the number of years, but additionally the fact that if you are convicted of a crime, you automatically have access to the review process, but if you take a plea, you're not. And why that distinction is made is lost on me.
Well,
why we would do that.
I'm sorry. So maybe you had said that originally. What you just said, that was a new piece of information that I wasn't aware of. In this particular case, there has been a request made for the approval of the state's attorney to have a review of the sentence, and that application has been, or that request has been pending for 4 years?
Originally came through the state's attorney's office, which it was Jim Thomas at the time, and what he told us was that well, although he wasn't approving it, he wasn't closing the case, that he wanted to see it again in the near future. I don't know what he meant by that, but now he's gone. It's been 3 years and the application is still there.
Have you followed up at all?
I try. I made so many contacts, so many different people that I try to approach to. Now I believe the lady's name is Gail Hardy, which I even tried through the congressman office, Congressman Larson office, wrote to her concerning that.
Well, we're certainly going to debate this bill, and I don't know what the outcome of that debate is going to be in this committee. But let me just say that you deserve an answer.
Yeah.
Whether it's the answer you want or not, I don't know, but you deserve an answer. And I know that there are people in this room who can make sure you get that answer, and you hopefully will hear from them very shortly.
Thank
Okay?
you. Thank you.
Are there any questions? If not, oh, I'm sorry, Representative Dillon.
I just simply want to add, I'm shocked that that hasn't been acted on. And I was thinking while you were speaking, if you could come up with some language that would require action by a certain period if there's an application. Of course, I don't know what the penalty would be, so that would have to be thought through. But I wonder, did you think about anything like that, Senator? And thank you so much, ma'am, for your testimony.
Thank you.
Well, again, it's not to say that there ought to be an automatic right to a hearing, because that would open the floodgates. But there are legitimate cases, as I believe is the case with Ms. Torres Sullivan's husband, where there's a legitimate case for a hearing. So there's a three-step process right now if you've taken a plea. One is that you have to get a prosecutor to agree. The law in Connecticut previously did not require that a prosecutor agree.
Right.
It was simply an application to the judge,
Right.
and the judge would make the decision as to
Right.
whether or not there ought to be a hearing for modification. It certainly didn't mean that there would be a modification. And that's what this bill does, is it removes the prosecutor and has the application go directly to the judge.
Correct.
And that's what we're really seeking here, is the opportunity to get a fair consideration of whether there ought to be a hearing. And we certainly wouldn't want something that simply said, answer it within 30 days, where they say no within 30 days every time.
Senator, in your research, did you uncover the legislative history of why a new provision was added and when that required the prosecutor to agree? And it would be interesting to measure the effect on the appeals.
Well, again, right now you have access to the three-judge panel if you don't take a plea. There is no intervening step of a prosecutor saying yes or no. And my request of the committee would be to remove that language that says that if you've taken a plea, and as I testified to earlier, there's any number of reasons why someone would take a plea, and it certainly doesn't suggest that you agreed necessarily with the amount of years that you're being sentenced to, or that you're agreeing to a sentence. Could be any number of reasons. So, thank you.
Are there any further questions? If not, thanks very much.
Thank you, Mr. Chairman. Thank you.
We are past the 1 hour, and what we've been doing this session is moving to the public portion of the sign-up and taking about 5 or 6 members of the public, and then weaving in any remaining public officials who are signed up to testify. So we will begin with the public portion of this, and the first person to testify is Jason Ortiz, followed by Chris Rutkowski.